All right, aloha everybody. Welcome to the 9:30 a.m. agenda, Government Reform Committee. We'll just jump right into it. First up, House Bill 1426, Executive Director, Campaign Spending Commission. Kristen or Gary.
Good morning, Chair, Vice Chair, members of the committee. This is Gary Kam. I am the General Counsel of the Commission. The Commission supports this bill. We've submitted testimony in support, and I would just like to add that currently, without the avenue to collect fines as a money judgment, the Attorney General's office has to seek a bench warrant for these respondents with bail up to $500 to compel payment of the fines and filing of reports. And if you look at our website on candidates who are non-filers, there are about 13 candidates that are currently referred to the Civil Recoveries Division of the Attorney General's office. So it's not a huge universe of respondents. Thank you.
Thank you so much. Appreciate your testimony. Sandy Ma, ED of Common Cause.
Good morning, Chair, Vice Chairs, members of the committee. Sandy Ma for Common Cause Hawaii. We support HB 1426 and we understand the need to recover fines. We're just concerned that any circuit court judgment is not appealable, and we understand that having appeals is a foundation of our democracy and our court system. And so that is just our concern there. And so thank you for allowing Common Cause to testify on this matter, and I'm available for any questions. Thank you.
Okay, thank you so much, Common Cause. We have individual Natalie Iwasa testifying in opposition. Is she here? No. Okay, that's all we have on the measure. Members, are there any questions of the testifier? Yes.
Thank you. For Campaign Spending Commission, please. Mr. Kam. Thanks so much. How does the Campaign Spending Commission advise a preliminary determination? How is the candidate notified? Is it by snail mail only?
I believe if we have an email, they are also notified via email, but it is also via first-class mail. That's required by law.
And it's not a signature requested document. It's just first-class mail?
Yes.
Okay, but I wanted to clarify that you are notifying electronically, and I was wondering if that should be a requirement, because I personally have issues with receiving U.S. Postal Service mail in a timely manner, and with that 20-day window, I would be more comfortable if it had a requirement for an electronic notification as well.
Okay, so the way the system works is when there's a report due and the due date comes and people don't file reports, we immediately issue a notice of late report. And then most likely then the candidate will file the report after receiving the notice. And then from there we can calculate the fines and we notify them of the fines, and they can either pay the fine or they can challenge it, in which case we will file a complaint with the commission. Once the complaint is filed, you're notified you're given the agenda before the next commission meeting where the complaint will be heard. The complaint is heard, the candidate has the ability to respond to the complaint. And then it is at that moment, at that meeting, the commission will vote to either dismiss the complaint, refer the case back to staff for further investigation, enter a preliminary determination of probable cause, or refer the case for prosecution. In the vast majority of cases, it is a preliminary determination of probable cause is entered, and then the second most is where they'll just dismiss a complaint, because filed between the time of the complaint and the hearing, the commission meeting, the fine will be paid. So then, focusing on the preliminary termination, that gets served upon the respondent, and then the respondent has 20 days to ask for a contested case hearing. If the respondent does not ask for a contested case hearing, within 20 days of receipt. So we have to show that you received it. Then the preliminary order becomes final. And then that's what we're talking about. That's what gets referred to the Attorney General's office if the fine is not paid within, I guess, within 2 weeks.
Okay, so
So-
the candidate's already aware that this is happening, this filing of the preliminary determination, they would have
That
already
is-
been involved in the process and looking for that. I
Yes,
just didn't
that-
want, like, I wouldn't want to be surprised that I missed a piece of mail and 20 days
No.
later, all of a sudden I'm in big trouble.
So the preliminary order is probably the fourth written document. The first one is the notice of late report, then the notice of fine, then the complaint with the agenda for the meeting that is going to be heard. And then at the meeting, like I said, the case is either dismissed if the fine has been paid or the preliminary order is entered. And then and that served on the respondent. And like I said, the time to ask for a contested case is within 20 days after receipt of the preliminary order. So we have to show that it was received. And
Okay.
then
Thank you very much. Thank you, Chair.
Okay, thank you so much. Other quick question of Campaign Spending Commission. You're still there, Gary. In regards to Sandy Ma's Executive Director of the Common Cause, her testimony with the concerns of cutting off all appeals through the judicial system and the potential constitutional and other issues that arise from that. Would you be, I guess, open, or what's your reaction or feedback on her requested amendment along those lines in her testimony? If she wants to speak in, if she's still here on the thing, by all means, go for it.
yeah,
Go ahead,
so
Sandy. Well, go ahead, Gary, first.
okay, so like I was saying in answer to Representative Wildberger's question, at this stage where we have sent the order to the Attorney General's office, and they're now trying to collect on the order, which presents some problems, and that's why we have this bill. The respondent has already been notified that you have 20 days to request a contested case hearing. So that is within the campaign spending. You request a contested case hearing, and that's handled by the commission, and then you have appeal rights from there. But in this case, they haven't requested a contested case hearing. And by law, the order becomes a final order. And the reason why it's not appealable is because it's an agency case without an agency record, because there's been no contested case. So there's nothing for an appellate court to review or the First Circuit Court to review. Agency cases are usually heard on the administrative record. There is no administrative record because there is no contested case hearing. So the ability to challenge the order then becomes under Rule 30. 30 is it? I cite the rule in my testimony where you can collaterally attack the order, but it has to be some of the reasons provided in the rule on collaterally attacking an order. So then, but even in that case, if you're successful in getting the order overturned, I don't think the circuit court is going to hear an agency appeal. They're going to remand it back to the commission to do a contested case hearing. That's where it all starts as far as jumping then into the judicial side. You need the contested case hearing.
Sandy, do you want to respond to Gary's interpretation of the measure insofar as contested case hearings go and the ability of the court to review?
Thank you, Chair. So yes, we just want to make sure that if there's the ability to collaterally attack the order and to refer it back for a contested case hearing, like Gary said. Thank you.
Sounds good. Well, it appears it may do that given the process, but we'll, should we move the measure forward, we'll put this in the committee report, but this is clearly a JUD discussion that should take place over there as well. So, okay, thank you both for testifying. We appreciate it. Next up is 1427. First up again is Campaign Spending Commission, Mr. Gary Kam.
Thank you, Chair, Vice Chair, members of the committee. The commission supports this bill, and I will stand on our testimony in support.
Okay, thank you so much. That's all we have actually on 1427. Sandy, since you're here, you want to weigh in or no?
This is a housekeeping measure. Thank you, Chair. Sandy Ma with Common Cause Hawaii, and this is a housekeeping measure.
Okay.
We did not have comments on this. Thank you.
Sounds good. Then that's good to know. Okay, that's all we have in 1427. Members, questions on the housekeeping amendment for campaign spending? Seeing a shake of the head, being there none. House Bill 1879, again, Campaign Spending Commission. Mr. Cam.
Good morning, Chair, Vice Chair, members of the committee. We have submitted comments and I will stand on our written comments.
Okay, noting the concerns of the commission on this measure. Next up, we have Sandy Ma, DD, again, Common Cause Hawaii.
Good morning again, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. Common Cause understands the state has important governmental interests in keeping the voters informed of who is advertising and trying to influence the voters in our elections. We suggest disclosure mechanisms for keeping voters informed. Disclosure mechanisms are proactive approaches in campaign finance versus this punitive reactive approach after voters may have already been influenced. And that is really our comment to this measure.
Okay, thank you
Thank
so
you.
much for the comments. That's all we have on the measure. Anybody in Zoom wishing to testify? Seeing none, members' questions. A quick question. I guess, Sandy, I'm gonna look to you. I mean, I saw the measure and I guess, I mean, grossly false or anonymous. I mean, wouldn't that kind of be starting to tread very on the First Amendment rights insofar as creating a subjective law like this?
That's a good question, Chair. Yeah, I mean, that really was trying, that was the point of our testimony, where we prefer disclosures that are proactive versus a reactive law that seeks to punish the advertisement, the content of the advertisement, which could be viewed as a First Amendment, questionable First Amendment, content.
It could potentially be a chilling effect then, would you say?
It could be. I mean, Gary or your AG could possibly give that opinion better than I can. But again, it struck a questionable note with Common Cause Hawaii when we were reading or reviewing the bill. So that's why we prefer disclosures as to who is donating in our elections versus trying to police advertisements like this.
Okay, and yeah, there are measures to that effect actually moving as well. Representative Ward, I see your virtual hand up. You have a question?
Thank you, Chair. My virtual hand is up to Mr. Cam, who I see virtually. Mr. Cam.
Yeah.
I don't know if this bill is prescient or it's something that, as of what occurred yesterday, does it have anything to do with that? And did you guys know anything before what happened yesterday? If you can respond to that. I'm talking about the two people who in the U.S. Attorney's office were accused of certain things. Bill looks like it was pre-made for something like that.
Yeah, so the FBI, they do not discuss the names of anyone that they are investigating. If they want information from us, it's basically they don't disclose that kind of information to us.
So why would this list the FBI and not the U.S. Attorney's office then?
Yeah, I'm sorry, this is not a campaign spending bill. So whoever introduced this bill,
But it affects your commission, right? It's directly to their jurisdiction. Anyway, is anyone else on the call that would know something about that? If not, thank you, Mr. Kemp. Thank you, Chair.
Thank you so much. Any other questions from the members? Okay, seeing none, let's move on to the next measure on the agenda. House Bill 1951. We have, again, Campaign Spending Commission.
good morning again, Chair, Vice Chair, members of the committee. Commission submitted comments and I'll stand on the written comment.
Okay, thank you so much. With the concerns have been noted. Sandy Ma, Common Cause Hawaii.
Excuse me, good morning again, Chair, Vice Chair, members of the committee. We provided comments regarding HB 1951. This bill provides that excess campaign funds of candidate committees may be donated to state and county funds, but the state and county funds are not defined in the bill. We're not quite sure why this bill was introduced then, if it's undefined state and county funds. And we feel like the Hawaii Election Campaign Fund could use the funds more to bolster our partial public funding of elections. And so we don't really understand this bill, HB 1951. So those are our comments. Thank you very much, and I'm available for any questions.
Okay, thank you so much. That's all we have on the measure. Is there anybody else in Zoom wishing to testify? Seeing none, members, questions? Quick question, I guess, either Sandy or Gary. So right now, can a candidate donate their inactive campaign residual campaign funds to the kind fund you mentioned earlier? Sorry, it's been a long day already.
Campaign fund?
Yeah.
Yeah, they can. It's not usually a donation though. It's usually after all the other options are used up, then the funds escheat to the Hawaii Election Campaign Fund.
Okay, so they automatically cheat to the election fund now, then, right?
That's the yes, it does.
Okay. Okay, sounds good. Okay, and never mind. I think you might have answered my question already. Okay, thank you so much. Appreciate it. Okay. Anybody else? One more time? Nope. 1880. First up, Hawaii Campaign Spending Commission.
Thank you. Good morning, Chair, Vice Chair, members of the committee. We've submitted comments on this bill, and I would just note that there is that HB 1888 that's moving, and it may be more prudent to just hold this bill.
Okay, thank you so much. Appreciate your testimony. Next up, we have Common Cause Hawaii.
Morning again, Chair, Vice Chair, members of the committee, Sandy Ma for Common Cause Hawaii. We submitted testimony in support of HB 1880 with suggested amendments. We understand that this bill removes the qualifying amount triggering the filing of statements of information for electioneering communications. So this would result in filing of statements of information for any amount of electioneering, any amount that anybody spends on electioneering communications by a non-candidate committee. And so this may cause a lot of statements of information to be filed. So while there are other bills that are moving, we do like more transparency and disclosures. So that's why we do support this bill, but we also understand that this could cause more work for the commission. We suggested a couple other amendments that are stated in our testimony, and I'm available for any questions. Thank you.
Thank you so much. That's all we have on the measure. Anybody else wishing to testify on Zoom? If not, committee members' questions. If not, a quick question for Campaign Spending Commission. I don't know if you have a chance to see Common Cause's testimony, but yeah, would this create a huge resource issue for your office and being able to, I guess, process all of these statements that are coming in because it encompasses any amount whatsoever?
I would say yes to that question if the candidates still had to file these statements of information. But since it's just non-candidate committees now, I don't think it's going to be a huge problem because they don't follow as many of these. They don't have as many expenditures for electioneering communications that candidates used to have. But I will say that if you take out the threshold, I cannot see a court upholding some kind of disclosure for like paying $50 or $100 for an electioneering communication. I think that would be a little low. So I think we have these thresholds in there for legal reasons, and taking that away, I think would cause problems for 11-341. But that's why I said, we have 1888 still in play out there, and I think there's some bills on the Senate side also, that keep the threshold.
Okay. Sandy, any response?
Those are all reasonable comments by the Campaign Spending Commission.
Okay, thank you so much. Appreciate you guys' input on this. We will move on to the next item on the agenda. We have House Bill 2376 regarding the cap. First up is Campaign Spending Commission.
Good morning again, Chair, Vice Chair, members of the committee. The commission submitted comments, and I will stand on those written comments.
Thank you so much. We also have Sandy Ma, Common Cause Hawaii.
Good morning again, Chair, Vice Chair, members of the committee. Common Cause Hawaii opposes HB 2376, which repeals the cap for the amount of campaign funds candidates may donate to nonprofits, charitable institutions, etc. That's because we are concerned that removing the cap as proposed by HB 2376 would create a conflict of interest and an appearance that votes were cast in exchange for a donation from a candidate's campaign fund. So we oppose this bill. Thank you. And I'm available for any questions.
Okay, thank you. I believe that's all we have on 2376. Anybody on Zoom wishing to testify? If not, members, questions? Quick question, I guess I have Sandy. You mentioned the appearance of impropriety that may exist insofar as donating, but wouldn't that impropriety exist regardless of the amount? I mean, you're making a donation to this charitable fund. Why would a threshold amount all of a sudden now create this air of impropriety?
You're correct, Chair. We don't like the donation at all. So we prefer that the donation not exist. But we certainly don't want the cap to be removed.
Okay, so your issue is with the underlying existing statute then, right?
Correct. We
Okay.
just didn't feel like proposing to remove the donation would be feasible. And so we just didn't propose that amendment.
Okay, well, maybe that's something that this could turn into a vehicle for. Rep Ward, your virtual hand is up. Go ahead, sir.
Thank you, Chair. Mr. Cam, in terms of supply and demand, are there people saying, hey, I want to give more money to my school, I want to give more? Is there really anybody who approaches you with this demand, or anybody on this call, I mean, on this Zoom meeting? I've never heard of the need to do the cap unless there's something I'm missing. Mr. Cam, do you have requests for this?
Requests for whether or not
I mean, they want to give more money than is now allowable. I guess it's twice the maximum amount, which would be what, 2,000. So 4,000 looks to be the cap. Have you had requests saying, hey, I want to give $10,000 to the school down the street or something?
No, I mean, people know what the law presently says, so they wouldn't come to us for that kind of concerns. They would probably go to people like you folks.
Okay, so I should probably ask unless Sandy, you know something about this, I should probably ask the author.
The governor?
The governor.
The governor's bill.
Thank you, Chair. Well, that's a labyrinth we may not be able to follow, though. Thank you.
Okay. A real quick question then. I'll just tag on to there. Who would be the enforcement entity should that, I guess, a concern be raised that the threshold amount was exceeded by a contribution?
It would be us.
It would be you guys right there.
Yeah.
Okay. So have you ever had any kind of action like this in the past, or like you said, it's self-policing because it's in the statute?
I think I may be thinking about another bill, but I think we did have a question come up, and it was concerning a candidate who is no longer going to run, and they're just looking at ways to, deal with the surplus that they have, and this might be the bill that is trying to address that. I'm not sure.
So that begs the question, I guess, what if the candidate is no longer running for office, or I have my vice chair noted that was actually on top of Or might as well, yeah, on that note, what if the person is not running
They're not
again
running or retiring.
or retiring?
War chest to dispense of.
Yeah,
The money would have to be spent pursuant 11 to 11-381, which has a cap. So you'd still have to abide by the cap.
so what about all the other monies that are sitting in there then? I mean, they would just sit there, they would cheat to the Hawaii Elections Fund, I mean, what would?
Well, yeah, I mean, there is a charitable organization, there is a public school, there is a public library. You could still buy 2 tickets, I guess, to another candidate's event. I guess you wouldn't be campaigning anymore, but whatever is left would escheat to the Hawaii Election Campaign Fund.
Okay,
Which funds are partial public funding, so it's not like it's not getting put to good use.
okay, so those excess funds above the cap would then cheat to the fund that is used to help to fund the public financing program, correct?
Above the caps and above anything else that you can do pursuant to 11-381.
Any more follow-ups, Vice Chair? No?
Thanks.
Okay, thanks so much. Appreciate you guys' feedback on the measure. Next up is, my glasses are fogging up, 2007, I believe it is. First up, we have State Procurement Office.
No, we missed one.
Oh, we did miss one.
2474.
Oh, sorry. My glasses are fogging up. Let's go back. 2474, first up, Campaign Spending Commission.
Good morning again, Chair, Vice Chair, members of the committee. The commission had submitted testimony in support of this bill, and I will stand on that testimony. Thank you.
Okay, thank you so much. Sandy Ma, Common Cause, Hawaii.
Good morning, Chair, Vice Chair, and members of the committee. Sandy Ma for Common Cause Hawaii. We support in part and oppose in part HB 2474. We support that provision that provides that if you are convicted under Hawaii Revised Statute Section 11-412, that you should be disqualified from holding elected public office for 10 years from date of conviction. Maybe it's also if you plead guilty now. And then we actually do question or oppose that portion of Section 2 of the bill that permits the commission from referring a complaint to the Attorney General or County Prosecutor without a belief that a respondent recklessly, knowingly or intentionally committed a violation. We believe there should be some notice to the public of some minimum threshold of misconduct before a criminal referral may be made. And that's just for notice to the public. Thank you, and I'm available for any questions.
Okay. That's all we have on 2474. Anybody on Zoom wishing to testify? Seeing none, members, questions of you to testify. Okay, seeing none, we'll move on to the next bill of the agenda, which is the procurement one, 2007. First up, we have DAGS, Bonnie Kahakui, Acting Administrator.
Good morning, Chair, Vice Chairs, members of the committee. Bonnie Kahakui for the State Procurement Office. We stand in our written testimony providing comments and clarify that we are opposed to making any changes to the protest bond. Thank you.
Thank you so much. Next up, we have the General Contractors Association of Hawaii.
Good morning, Chair McKelvey, Vice Chair Wildberger, members of the committee. The GCA is in support of the measure, but we ask that the measure actually be amended to conform with other states' procurement codes. So last year, the legislature enacted legislation that requires a party protesting an agency decision to put up a 1% cash or protest bond without a cap. So previously, there was a cap of $10,000. The purpose of the cash protest bond is to prevent the filing of frivolous appeals by ensuring that people put some skin in the game. We agree with this. However, we believe that the legislature inadvertently left out safeguard language that the other states who require these cash protest bonds without a cap use for appeals to prevent the chilling effect of deterring legitimate protests on large projects. So the safeguard language that the other states use allows for the return of the bond minus the administrative costs associated with hearing the appeal, unless the appeal is found to be frivolous or in bad faith. So there are two ways to prevent the chilling effect of deterring legitimate appeals on large projects. You can have a bid cap, which this measure currently does, Or you can allow for the return of the bond minus the admin costs unless the appeal is frivolous or in bad faith. So since Hawaii adopted language that the other states used last year to increase the amount of the cash bond required without a cap, we believe that the measure should be amended to include the accompanying safeguard language that every other state uses. So I want to emphasize, as of last year, Hawaii is now the only state that requires a bond that doesn't include safeguard language to prevent deterring legitimate protests on agency decisions for large projects. Mainly, my members feel that this would affect projects over $15 million. So to us, this is an ethics bill. Essentially, the effect of the removal of the bond cap provision last year without adopting any other safeguard language is that it prevents bidders from appealing an agency's bid protest decision on large projects because it raises the cost of the appeal so high that it becomes unaffordable and no longer fiscally prudent. So this altered the landscape of the procurement code by reducing one of the checks and balances, and it removed any realistic oversight of decisions on large projects. So given the current climate, we think this is a no-brainer that helps restore the public trust in government. Happy to answer any questions.
Okay, thank you so much. We have Brendan Baker and Mark Berg, ACH, which is the Airlines Committee of Hawaii. Written testimony in opposition, and we have Late from the Department of Transportation.
Thank you, Mr. Chairman. The Department of Transportation is opposed to the measure, and we will stand on our written testimony. Thank you very much.
Okay, thank you so much. That's all we have on 2007. Is there anybody on Zoom wishing to testify? Seeing none, the members' questions? Yes, Vice Chair.
I guess for maybe Mr. Sakuda, thank you. I appreciate your recommendation that the bonds minus administrative fees be returned. I noticed that the State Procurement Office testified that the number of bid protests did not go down once this measure was put in place. And I'm particularly concerned about the number of delays that have happened with the Kihei High School project. That project's been delayed up to a year just because of bid protests. So maybe we can do some kind of hybrid chair, since this is your bill, that will keep that financial obligation in place, but return.
Yeah, so Rep Wildberger, we don't feel that the removal of the cap was going to affect bid protests really on projects under $15 million. So I think the cap was set at $10,000. So basically a project at $1 million, there is no difference because you would still have to put up the $10,000. But when we start talking about a $15 million plus project, then you have to put up $150,000. And even if you have what you think is a legitimate protest, then you lose that bond. No other state that has a bond requirement requires that you lose it unless your appeal is deemed to be frivolous or in bad faith. Here, I think we adopted the standard that the mainland uses last year, and we're okay with it. We just didn't adopt the safeguard language to prevent the chilling effect of deterring legitimate protest, especially on large projects. So we don't think that you'll actually see a reduction in numbers if the projects are less than $15 million. That's where my members are saying they're not going to be willing to put up the financial risk. We spoke to an attorney that actually said she has a client that decided not to pursue a protest because they couldn't afford the bond.
Okay, thank you.
Okay, thank you. Rep Ward. Rep Ward, go ahead. You have a question? See your hand up. Virtual hand.
Sorry, I was muted. Sorry, Chair. Mr. Sakuda, you mentioned safeguard language twice. Are you suggesting that is the amendment, or you're just saying in the absence of it, it's unfair?
Well, in my testimony, I provided what I believe is the safeguard language that the other states used and how we could fit it into our. Basically, the state safeguard language is that every state that requires a bond of 1% without a cap has language within the procurement code that says you get the bond back minus the administrative cost of hearing the appeal, unless your appeal is deemed to be frivolous or in bad faith. Then you lose the bond, and we're okay with that because that will still deter frivolous protest. You will lose the $150,000 on a $15 million project if it's deemed in bad faith. And we agree with that. We want to kind of create a climate where we deter frivolous protests, but we don't actually deter legitimate ones. And that's where we need to strike the balance. Every other state has this language in there. We're the only ones that when we passed the removal of the cap last year, we didn't add any kind of safeguard language that the other states do. Or use.
49 states have what you
No,
just.
there's only 7 states that require the bond.
Oh, 7, okay, of those 7,
So of the Hawaii is one of the 7,
I see.
and the other ones have this language. And I included that research in the my testimony.
Okay, well, good testimony. Thank you for that. Thank you, Chair.
Thank you. You're welcome. Yeah, no, I introduced this bill because of that discrepancy because I think we left it out last year. However, as one who's trying to build a highway in my district, I can tell you I am no fan of frivolous protests at all. But at the same time, I think there is a need potentially, which is why we're hearing it, to look at not cutting off, ways for legitimate protests to be filed just simply based on finances. So anyway, great conversation, members. Let's move on to the next one on the agenda. House Bill 2066. We have State Procurement Office.
Good morning again, Chair, Vice Chair, members of the committee. The State Procurement Office stands on its written comments. Thank you.
Thank you so much. Let's see, we have next up, we also have the comptroller from Department of County General Services.
Aloha Chair, Vice Chair, and members of the committee. Chris Kinimaka, DAG's Public Works Administrator, on behalf of the State Comptroller Otaguro, we stand on our written testimony in support. Mahalo.
Okay, thank you so much. We have Andrew Kawano, Director, City County Honolulu, Department of Budget and Fiscal Services. Okay, we've written testimony in support. However, they're requesting some amendments. Ryan Sakuda, General Contractors Association of Hawaii.
We just stand on our written testimony.
Okay, in support, noting that. We have late from Christine Kinamaka as well from the Accounting and Department, DAGs again.
Chair, Vice Chair, that was just myself registering as backup for the State Comptroller.
Oh, got it. Okay, no worries. The more the merrier, right? Okay, that's all we have on 2066. Members, any questions on the measure from the administration? Seeing none, let's move on to the next one on the agenda, which is House Bill 2067. First up again, DAGs.
Good morning, Chair, Vice Chair, and members of the committee. Chris Kinimaka, DAG's Public Works Administrator, on behalf of the State Comptroller, standing on our written testimony in support. Mahalo.
Okay, thank you so much. Again, we have Andrew Kawano, City and County Honolulu, written in support. We have Malcolm Barakarsi Jr., past chairman of the Associated Builders and Contractors Hawaii chapter. Okay, written in opposition. We also again have Christine again as an individual from DAGs in support. Ernest Lau, PE, manager and chief engineer of the Board of Water Supply. Is he guy these days?
Yes, yes, the Board of Water Supply stands on its written testimony in support.
Okay, thank you so much. Next up, we have Jay Butai, Director of DOT or designee.
Mr. Chairman, Patrick McCain with the Department of Transportation. We will stand on our testimony in support of the measure. Thank you very much.
Okay, thank you so much. Randy Pereira, President AFL-CIO. Okay, we have written testimony from him in opposition on behalf of AFL-CIO. We also have late testimony from Analyst Sonoa Tuiasopo, Hawaii District Representative for Operating Engineers Union Local Number 3. Written testimony in opposition. That's all we have on 2067, this admin bill. Is there anybody in Zoom who I might have missed or would like to testify? Seeing none, members' questions of any of the testifiers? No? Okay, noting those concerns that were raised. Next up, we have House Bill 2068. First up, we have Jan Goveo, Vice President of UH of Hawaii System. Written in support. We also have Bonnie Kahakui, State Procurement Office.
The State Procurement Office stands on its written testimony in support. Thank you.
Okay, thank you so much. We have Kurt Odagura. Oh,
Sorry, this is Jamie Ho. I'm representing Jan Govea from the University.
Oh, yeah, go ahead. Then.
Sorry. Sorry, I have a little bit of a problem with my mute button. The University of Hawaii stands in its written testimony in support.
Okay, thank you so much. Thank you for being here. Appreciate it. Yeah, stick around for questions if we need be. Let's get back. I believe we were at Kurt Otagura, Comptroller.
Hello, Chair, Vice Chair, members of the committee, Chris Kirimaka, Public Works Administrator, on behalf of the State Comptroller, and DAG stands on our written testimony in support. Mahalo.
Thank you so much. Andrew Kawano, again, City and County Honolulu Budget and Fiscal Services, written in support. We have Christine as an individual, re-echoing the support that was made earlier. Ernest Lau, PE Manager and Chief Engineer, Board of Water Supply.
Yes, this is Kathy Mitchell with the Board of Water Supply for Ernest Lau. We stand on our written testimony in support. Thank you.
Thank you so much for being here. Appreciate the work you guys are doing. We
Thank you.
also have late Ryan Sakuda, General Contractors Association of Hawaii.
We stand on our testimony.
Okay, in support. We also have late Jade Butai, Director, DOT. I guess Patrick would be the one.
Thank you, Mr. Chairman. Patrick McCain, Department of Transportation. We will stand on our testimony in support of the measure. Thank you very much, sir.
Okay, thank you so much. Good to see everybody on the same page on this one. That's all we have on 2068. Is there anybody in Zoom who'd like to testify or I did not call? Seeing none, members, questions of any of the testifiers on this bill? Seeing none, let's move on to 2504. We're going to start up with State Department of Human Services. Okay, written testimony with comments. We have Kurt Otagura, Comptroller of DAGS. Okay, written testimony in opposition. We also have late from the State Procurement Office.
Good morning, Chair, Vice Chair. The State Procurement Office stands on its written testimony in opposition. Thank you.
Okay, thank you so much. And then we have, let's see, Department of County and General Services, Christine Kinamaka.
Hello, Chair, Vice Chair, and members of the committee. I registered to testify on behalf of State Comptroller DAGS, for DAGS, Kurt Otaguro, and we stand on our testimony as submitted in opposition of the bill. Mahalo.
Okay, thank you so much. And then we have late DOT, Patrick, with comments.
Thank you, Mr. Chairman. We will stand on our testimony.
Okay, thank you so much. All we have on 2504, anybody else out there wishing to testify? Seeing none, members, questions of the testifiers? Seeing none, we'll move on to 2349. First up, DLNR. Okay, we have comments and they're requesting an amendment. Next up, we have.
We're here if you have any questions. Aloha.
Okay, go ahead then.
We're just standing on our testimony.
Okay, and you are requesting an amendment, right?
That's correct.
Okay, thank you so much, Emma. Let's go with State Procurement Office.
The State Procurement Office stands on its written testimony providing comments. Thank you.
Okay, thank you so much. That's all we have on 2349. Is there anybody in Zoom who'd like to testify? Seeing none, members, questions to either DLNR or Procurement Office? Seeing none, I believe that takes us to the end of the hearing agenda for today. So we will recess for decision-making on the bill previously heard in these ones. Much, everybody. Welcome back. We're going to go ahead right into decision making. First up is a short form we'd like to use for discussion on procurement. So therefore, the recommendation is that we voted out for recommittal to have a hearing on the contents at a later date. Members, questions, comments? If not, Vice Chair, 1909 short form.
Thank you, Chair. Your recommendation to pass HB 1909 as a short form and recommit for future public hearing. Chair and Vice Chair voting aye. Representative Eli is excused. Representative Ichiyama also excused. Representative Mizuno also excused. Representative Woodson.
Oh, there's Chama.
Oh, good. Oh, shoot. Gotcha. Representative Ichiyama? Aye. Representative Mizuno is excused. Representative Woodson? You're muted. Representative Woodson?
Aye.
Thank you. Representative Yamashita?
Aye.
Representative Ward?
Aye.
Thank you, Chair. Your recommendation is adopted.
Okay, thank you, members. Appreciate your support. HB 1908 relating to procurement. What we're going to do is we're going to add a 2-year sunset clause as was requested by the Subcontractors Association. We're going to also add clarifying language that the 24-hour period is complementary and in addition to what is allowed under 103D-302G, which is the discretionary right of the hearing officer to go ahead and allow a substitution, which was also raised as a concern of the Painters and Glazers Union. We're going to add technical non-substantive amendments for clarity and style, and we're glad to see these parties talking on this issue to resolve this long-standing issue in procurement. So we want to encourage further conversation. Added effective date of 21/12, so the next committee can bring it up with the parties and they can continue to discuss both the measure and the amendments being made. Members, questions, comments? If not, Vice Chair, 1908, House Draft 1.
Thank you, Chair. Your recommendation to pass HB 1908 with amendments. Chair and Vice Chair voting aye. Representative Eli?
Aye.
Representative Ichiyama? Aye. Representative Mizuno? Still excused. Representative Woodson?
Aye.
Representative Yamashita?
Aye.
Representative Ward?
Aye.
Thank you, Chair. Your recommendation is adopted.
Okay, next one, 2492. We recognize it's a controversial measure that's, however, it warrants more discussion. And being such, we want to make some amendments to help move that along. So pursuant to the amendments suggested in testimony, we're going to delete section 1, page 1, lines 10 through 16, and page 2, lines 1 to 2 regarding professional services disqualified vendors. We're also going to remove section 5, creating the liability fund, and instead we're going to ask the State Procurement Office to research and report to next year's legislature on the creation of a liability contingency fund and what appropriate percentage would be required. We're also going to go ahead for the appropriation section. It will remain blank. However, in the committee report, we're going to recommend the suggested $944,000, which encompasses holding the task force and the full-time positions. However, we're going to ask the Committee on Finance to really dig into those numbers because they seem a little bit high to do what we're requesting them to do. We're also going to add an effective date of 21/12 for further discussion. And also in the committee report, we're going to note that the bill encompasses all professional service contracts, and it's not meant to single out design or other professionals in particular. Members, questions, comments? If not, Vice Chair, 2492, House Draft 1.
Thank you, Chair. Your recommendation to pass HB 2492 with amendments. Chair and Vice Chair are voting aye, noting Representative Mizuno's excused absence. Do any other members have no or reservations? Thank you, Chair. Your recommendation is adopted.
Okay, thank you so much. House Bill 2071, what we're going to do in this measure here is we're going to remove section 1. Then we're going to go ahead as far as section 2 being identical to section 103D-312, which is already required for them to provide full detailed budgets for purchases of health and human services. We're going to ask the next committee to look into that issue. And an effective date of 21/12. Members, questions, comments? Yes. Oh, Recess. Bad, guys. It is actually the section one's the purpose section. So want to leave that in there. We're going to remove section 2. And then as discussed earlier, we're going to have the next committee look at that issue that was brought up by Hano. And it's effective date of 21/12 to that effect. Members, questions, comments? If not, Vice Chair 27B1 HD1.
Thank you, Chair. Your recommendation to pass HB 2071 with amendments. Chair and Vice Chair voting aye with Representative Mizuno excused. Do we have any other no or reservation votes? Thank you, Chair. Your recommendation is adopted.
Okay, 2183, procurement of professional services, yet another take on the issues thereof. What we're going to do is we're going to take the suggested amendments of the State Procurement Office insofar as page 1, line 5 through 10, to put in a request for alternative procurement approval so that there's less than 3 qualified professional service vendors submitting bids, that the entity can go ahead and submit a request to the Chief Procurement Office or designee thereof to have an alternative form of procurement for them to use. We noted that ASEC, when testified that they were going to provide language to address their concerns after meeting with their members last Monday. However, we did not receive that from them. So hopefully we're going to put in the committee report to have the next committee, should they want to hear the measure, follow up on what their suggested language would be to assuage their concerns, which we believe the SBO amendment kind of assuages them to begin with. A defective date of 21/12 for that further conversation. Members, questions, comments? If not, Vice Chair 2183, House Draft 1.
Thank you, Chair. Your recommendation to adopt 2183 with amendments. Chair and Vice Chair voting aye. Representative Mizuno is excused. Other members with reservations or no votes? Thank you, Chair. Your recommendation is adopted.
Okay, next up, 2252, awesome bill. Co-signed it because it is an awesome bill. That being said, we think it's pretty good as the way it is. So we are going to make technical non-substantive amendments for clarity and style and move the measure out with just those amendments. Members, questions, comments? If not, Vice Chair 2252, House Draft 1.
Thank you, Chair. Your recommendation to pass 2252 with amendments. Chair and Vice Chair voting aye. Representative Mizuno excused. Any noes or reservations from the other members? Thank you, Chair. Your recommendation is adopted.
Thank you. 2386 relating to elections, similar to another measure that's moving elsewhere. Well, we're going to, however, there are concerns and issues brought up with making it digital only, given some people may not be digitally literate, and especially our Kapuna population and those geographically challenged, like out in East Maui. So what we're going to do is we're going to provide basically a way where a person can request from the Office of Elections a physical copy of the digital voter guide that would be mailed to them. We're going to note in the committee report $95,000 is a recommended amount of money to finance. And we feel that given it's a request only system, that the $95,000 appropriation should encompass that as a way to create flexibility for those who are digitally challenged or in a geographically disadvantaged area. Effective date of 21/12 for further conversation on the amendments. Members, questions, comments? No, go.
Chair, does it state who actually makes the narrative? I mean, is it somebody inside that office, or is it where the candidate feeds information?
It's the candidates themselves, and they're limited to 150 words. So those who are more flowery are not advantaged against those who are less flowery.
Okay, I didn't read that it was the candidate that actually did that in the bill. It wasn't clear in the bill.
Yeah, well, that's a good point. I believe they submitted to Office of Elections.
At least my reading of it. Anyways, thank you for that.
Yeah. Well, we got an effective date, so we'll definitely follow up on that to make sure we're crystal clear insofar as how the process would work. But thank you for those thoughts, and we'll throw them in the committee report too to flag it, okay? But that's the way we envision it working insofar as
Thank you.
Okay, any other questions, comments, or concerns with 2386? If not, Vice Chair, 2386, House Draft 1.
Thank you, Chair. Your recommendation to pass HB 2386 with amendments. Chair and Vice Chair voting aye. Recognizing Representative Mizuno's excused absence. Any other members with reservations or no votes? Thank you, Chair. Your recommendation is adopted.
Okay, thank you, members. For the items that were heard on today's agenda, we're going to defer them all time certain to Friday at 9:30 a.m., room 309. That concludes this hearing. Thank you for being here. Appreciate it.